Uh,
ಪಾಟೀಲ್ ಕೇಳ್ತಾ ಇಲ್ಲ. ಅಮಿತ್ ಅವರು ಪಾಟೀಲ್ ಹೇಳ್ತಾರೆ.
Mr. S.C. Patil sir is probably there is some technical difficulty with him to he is not audible. Therefore, let me take this opportunity to introduce the honorable speaker of today's webinar, Mr. Krishnan Venkatraman. Krishnan Venkatraman has a degree in law from the University of Delhi. He also has a degree of Masters in Science, in Engineering Science from the Harvard University, Cambridge, including a coursework at MIT. He has completed his bachelor's in technology, that is civil engineering, from Indian Institute of Technology, Mumbai. He has a vast professional experience of helping and resolving arbitration litigations mainly. He has been advising on contract management of engineering contracts, working exclusively with the National Highways Authority of India and other public bodies in the dispute resolution arising out of large infrastructure projects. He has been servicing the contract, he has experience in servicing the contract management requirements of various projects. The present activities include arguing cases before DRBs and arbitral tribunals, drafting, pleading, and researching the validity and feasibility of claims. He has worked with a number of clients for the conceptualization, drafting and vetting, negotiation, etc. of contract documents relating to infrastructure sector, vetting infrastructure contracts and providing opinions towards litigation cases of other contracting companies. His academic interests are equally very high. He has worked in the public systems group on the analysis of the infrastructure and telecom sectors. The outcomes of the analysis were published in various reputed journals and books. He has taught as a visiting faculty in the Indian Institute of Management, Ahmedabad, in courses associated with infrastructure law and contract management. He has been teaching, including the courses for PGP in MBA students, senior executives from infrastructure companies, and senior civil servants. He has conducted workshops and training sessions for various infrastructure companies on issues relating to contract management. He has numerable clients like NHAI and many to name. More important is that he is an erudite scholar of Dharma Shastra. He has a special interest in learning Mitakshara, the original text of Mitakshara, which is in Sanskrit language, and he has the equipment to understand Mitakshara from the Sanskrit text itself and to interpret it in the language known to us in Hindi as well as in English. He is fluent in Hindi as well as in English. Welcome, sir. Welcome, Sri Krishnan, sir, to this webinar. On behalf of the trust and all the members of the trust, we offer you our sincere thanks for accepting this, and we are looking forward that the participants will be enlightened by this today's session, which will continue tomorrow at the same time as well as day after tomorrow also. Now I take this opportunity to also welcome the honorable presider of this webinar, Shri Suresh V. Nadagaudar. Shri Suresh V. Nadagaudar has been an epitome of knowledge, has been guiding many students of law throughout his career. There is no such ample time for us to actually enlist his achievements in academics. The achievements of Suresh V. Nadagaudar, who is presently the principal of the University Law College, Bangalore, are so ample that we would exhaust the whole of the webinar time in introducing him with his achievements. Most of the students and the lawyers now practicing from the state of Karnataka are much aware about his achievements. I will take this opportunity to welcome Sri Suresh V. Nadagaudar to this webinar and for having accepted our request to preside over this webinar. I welcome Sri Basaraj Patil Sedamji, who is the chairman of Vijnaneshwara Pratisthana Trust, Martur, who is also the chairman of Kalyana Karnataka Agriculture, Human Resource and Cultural Society, who is also the former member of Parliament, Rajya Sabha. He is known amongst all of us to be a very simple person, throwing light into the political and the social lives of all of us. He is also an educationist first. I welcome on behalf of the entire trust and its members, Sri Basaraj Patil ji, to this webinar. I especially welcome the Honorable Justices of the Honorable High Court of Karnataka, Justice Sri V. Srishananda, who has taken pains to join this webinar despite his busy schedule, and this being a Friday evening, we all are aware that there are many loads of works that the Honorable Justices have to accomplish on the Friday evenings after a tiresome work of a load of a week. I also welcome His Lordship Justice Srinivas Harish Kumar, the Honorable Judge of the High Court of Karnataka, who is now the senior most judge sitting at the Kalaburgi bench. I welcome learned Solicitor General of India, Sri M.B. Nargund, advocate practicing in the High Court of Karnataka at Bangalore mainly. I welcome all other advocates who have participated in this webinar. I welcome the students of law. I welcome the professors and the principals of various law colleges. I especially welcome the Honorable Vice Chancellor of Central University, Kalaburgi. I also welcome on behalf of the trust the other friends who have joined this webinar, showing their keen interest in the particular topic. I now request Mr. Sri Mahadevaya Kardaliji to give an introductory note about this webinar. Mahadevaya ji, please.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. ಇವತ್ತೊಂದು ವಿಶೇಷ ದಿನ ನಾವೆಲ್ಲ ಸೇರ್ತಾ ಇದ್ದೀವಿ. ಜನವರಿ 6, 1123, ಸರಿಯಾಗಿ 900 ವರ್ಷಗಳ ಹಿಂದೆ ಮರ್ತೂರಿಗೆ ಈ ದೇಶದ ಆಸೇತು ಹಿಮಾಚಲದಿಂದಿರ್ತಕ್ಕಂಥವ್ರು ಆಡಳಿತ ಮಾಡಿದಂಥ ಚಾಲುಕ್ಯ ವಿಕ್ರಮಾದಿತ್ಯ 6ನೇ ಇವರು ಮರ್ತೂರಿಗೆ ಭೇಟಿ ಮಾಡಿದಂಥ ಒಂದು ಪುಣ್ಯ ದಿನ ಇದು. ನಮ್ಮ ದೈವ ಇವತ್ತಿನ ದಿನ ನಾವೆಲ್ಲರೂ ಈ ಶುಭ ಸಂದರ್ಭದಲ್ಲಿ, ಈ ಸದಾವಕಾಶದಲ್ಲಿ ನಾವೆಲ್ಲ ಉಪಸ್ಥಿತರಿದ್ದೀವಿ. ಸೊ ಎಲ್ಲರಿಗೂ ಅಭಿನಂದನೆಗಳನ್ನ ಸಲ್ಲಿಸ್ತೇನೆ. ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಭಾಗವಹಿಸಿದಂಥ ಎಲ್ಲ ಹಿರಿಯರಿಗೂ, ಸಂಪನ್ಮೂಲ ವ್ಯಕ್ತಿಗಳಿಗೂ, ಮಾನ್ಯ ನ್ಯಾಯಾಧೀಶರಿಗೂ, ಪ್ರಾಚಾರ್ಯರಿಗೂ, ವಿದ್ಯಾರ್ಥಿಗಳಿಗೂ, ನ್ಯಾಯವಾದಿಗಳಿಗೂ ಎಲ್ಲರನ್ನೂ ನಾನು ಸ್ವಾಗತಿಸ್ತೇನೆ. ಆದ್ಮೇಲೆ ಇವತ್ತಿನ ದಿನ ನಮ್ಗೆಲ್ರಿಗೂ ಇಡೀ ಭಾರತದಲ್ಲಿ ಮಿತಾಕ್ಷರ ಯಾವುದಂತ ಗೊತ್ತಿತ್ತು, ಆದ್ರೆ ಮಿತಾಕ್ಷರನ ಕರ್ತೂರ್ನ ಜಾಗ ಯಾವುದು, ಕಾರ್ಯಕ್ಷೇತ್ರ ಯಾವುದಂತ ಗೊತ್ತಿರಲಿಲ್ಲ. ನಮ್ಮೆಲ್ಲರಿಗೂ ಮಾರ್ಗದರ್ಶಕರು, ನಾಡಿನ ಖ್ಯಾತ ಚಿಂತಕರು, ಶ್ರೀ ಜಸ್ಟಿಸ್ ನ್ಯಾಯಮೂರ್ತಿ ರಾಮ ಜೋಯಿಸರವರ ಪ್ರಯತ್ನದಿಂದ ಅವ್ರು ಯಾವಾಗ ಪುಸ್ತಕ ಬರಿತಾ ಇದ್ರು, ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಇಂಡಿಯಾ ಪುಸ್ತಕ ಬರೆಯುವಾಗ ವಿಜ್ಞಾನೇಶ್ವರ ಮರ್ತೂರ್ ಬಗ್ಗೆ ಉಲ್ಲೇಖ ಬಂದಾಗ ಹುಡುಕೊಂಡು ಮರ್ತೂರಿಗೆ ಬಂದು ನೋಡಿ ಇಲ್ಲೊಂದು ವಿಜ್ಞಾನೇಶ್ವರಿಗೆ ಒಪ್ಪುವಂತ ಸ್ಮಾರಕವನ್ನ, ಸಂಶೋಧನೆ ಕೇಂದ್ರವನ್ನ ನಿರ್ವಹಿಸಿ ಇಡೀ ಜಗತ್ತಿಗೆ ವಿಜ್ಞಾನೇಶ್ವರರು ಕನ್ನಡಿಗರು, ಭಾರತದವರು ಅಂತೇಳಿ ಕಲಿಸ್ಕೊಟ್ರು. ಬರೀ ವಿಜ್ಞಾನೇಶ್ವರನ ಅಧ್ಯಯನ ಇಲ್ಲ ಬಂಧುಗಳಲ್ಲಿ, ವಿಜ್ಞಾನೇಶ್ವರನ ಕಾನೂನಿನ ಅಧ್ಯಯನದ ಮೂಲಕ 1000 ವರ್ಷಗಳ ಹಿಂದೆ ಭಾರತ ಒಂದು ನಾಗರಿಕ ಸೊಸೈಟಿ ಆಗಿತ್ತು, ಸಿವಿಲೈಸ್ಡ್ ಸೊಸೈಟಿ ಆಗಿತ್ತು ಅನ್ನೋದನ್ನ ಜಗತ್ತಿಗೆ ತಿಳಿಸೋ ಸಲುವಾಗಿ ವಿಜ್ಞಾನೇಶ್ವರನ ಅಧ್ಯಯನವನ್ನ ನಾವು ಮಾಡಬೇಕು. ವಿಜ್ಞಾನೇಶ್ವರರ ಬಗ್ಗೆ ಆ ಶಾಸನದಲ್ಲಿ ಉಲ್ಲೇಖ ಇದೆ. ಇವತ್ತು ಭೇಟಿಯಾದ ದಿನ ಅವ್ರು ಭೇಟಿಯಾದ್ರು. ಎಲ್ಲ ವೈರಿಗಳಿಂದ ನೆಮಿಸಲ್ಪಟ್ಟಂತ ವಿಜ್ಞಾನೇಶ್ವರನು, ಇದು ವಿಕ್ರಮಾದಿತ್ಯನು ವಿಜ್ಞಾನೇಶ್ವರರ ಪಾದಗಳಿಗೆ ನಮಸ್ಕರಿಸುವಾಗ ಆತನ ಕಿರೀಟದಲ್ಲಿರ್ತಕ್ಕಂಥ ರತ್ನದ ಬೆಳಕುಗಳು ವಿಜ್ಞಾನೇಶ್ವರನ ಪಾದಗಳನ್ನ ಶೋಭಿಸ್ತಿದ್ವು ಅಂತಕ್ಕಂಥದ್ದು ವಾಕ್ಯ ಅಲ್ಲಿದೆ. ಅದು ಹಳಗನ್ನಡದಲ್ಲಿದೆ. ಹರಿರಾಯ ಮುಕುಟ ತಾಡಿತ ಚರಣ ನೆನಲು ನೆಗಳ್ದಿ ವಿಕ್ರಮಾಂಕನ ರತ್ನೋತ್ಕರ ನಿಚಿತ ಮುಕುಟ ತಾಡಿತ ಚರಣಂ ವಿಜ್ಞಾನ ದೇವರಂ ಕೇವಳಮ್ಮೆ ಅಂತ ಹೇಳಿ ಕೆಸಿ ಅಲ್ಲಿ ಬರೆದ್ರಿಂದ ವಿಜ್ಞಾನೇಶ್ವರರು ಇಲ್ಲಿಯವರು ಅನ್ನೋದು ಒಂದು ಖಚಿತವಾಗಿ ಆಗಿದೆ. ಈ ಮರ್ತೂರಿನಲ್ಲಿ ಕಾಳಿಂಗೇಶ್ವರ ದೇವಸ್ಥಾನ ಇತ್ತು, ಅಲ್ಲಿಂದ ನಾವು ಅದನ್ನು ವರ್ಗಾಯಿಸಿ ವಿಜ್ಞಾನೇಶ್ವರ ಭವನಕ್ಕೆ ತಂದಿದ್ದೇವೆ. 31/12/2004 ಅಂದಿನ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಮುಖ್ಯ ನ್ಯಾಯಾಧೀಶರಾದಂತ ನ್ಯಾಯಮೂರ್ತಿ ರಮೇಶ್ ಚಂದ್ರ ಲಾಹೋಟಿಯವರು ಕಲಬುರಗಿಗೆ ಬಂದು ಉದ್ಘಾಟಿಸಿದ್ರು. ಅವ್ರು ಹೇಳಿದ್ರು, ಇನ್ಮೇಲೆ ಮರ್ತೂರ್, ವಾಟ್ ಈಸ್ ದ ಮೀನಿಂಗ್ ಆಫ್ ಮರ್ತೂರ್ ಅಂತ ಕೇಳಿದ್ರು. ಫಾರ್ಗಾಟನ್ ವಿಲೇಜ್ ಅಂತ ಹೇಳಿದ್ವಿ. ನೋ, ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ಫಾರ್ಗಾಟನ್ ವಿಲೇಜ್, ಇದು ಇಟ್ ಇಸ್ ಟು ಬಿ ರಿಮೆಂಬರ್ಡ್ ಎವರಿ ಡೇ ಅಂತಕ್ಕಂಥ ಮಾತು ಹೇಳಿದ್ರು. ಎಲ್ಲರಿಗೂ ಕಾಶಿ ಹೇಗೆ ಧಾರ್ಮಿಕ ಕ್ಷೇತ್ರನೋ, ನ್ಯಾಯಾಂಗ ಕ್ಷೇತ್ರಕ್ಕೆ ಬಂದಂತ ಬ್ರೆಡ್ ಅಂಡ್ ಬೆಟರ್ಗೆ ಕಾರಣ ಆಗಿರ್ತಕ್ಕಂಥ ಮಿತಾಕ್ಷರ ಕರ್ತೃ ವಿಜ್ಞಾನೇಶ್ವರ್ಗೆ ಬರಬೇಕು, ಮರ್ತೂರು ನ್ಯಾಯಾಂಗದ ಕಾಶಿ ಅಂತಕ್ಕಂಥ ಮಾತನ್ನ ಅವತ್ತು ಹೇಳಿದ್ರು ಅವರು. ವಿಜ್ಞಾನೇಶ್ವರರ ಬಗ್ಗೆ ಹೇಳ್ಬೇಕಂದ್ರೆ ಅಲ್ಲಿ ಕಾನೂನಿನಲ್ಲಿ ಒಂದು ಹ್ಯೂಮನ್ ಟಚ್ ಇದೆ. ನಾವೆಲ್ಲ ಅವ್ರನ್ನ ಅಧ್ಯಯನ ಮಾಡ್ಕೊಂತ ಹೋದ್ರೆ ನಾನು ಜಾಸ್ತಿ ಹೇಳೋದ್ರ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಆದ್ರೆ ಮಿತಾಕ್ಷರದ ಕರ್ತೃ, ಮಿತಾಕ್ಷರದ ನಂತರ ಬಂದಂತ ಸುಮಾರು 63 ಏನು ಋಷಿ ಸಂತರು ಯಾರು ಕಾನೂನನ್ನ ಬರೆದಾರೆ ಅವ್ರು ಪ್ರತಿಯೊಂದರಲ್ಲಿ ಮಿತಾಕ್ಷರವನ್ನ ಕೋಟ್ ಮಾಡಿದ್ದೆ. ಮಿತಾಕ್ಷರನ ಗ್ರೇಡ್ ಅಗಾಧವಾದಂತ ನ್ಯಾಯಾಂಗ ಜ್ಞಾನವನ್ನ ಕಡಿಮೆಯಾಗಿ ಮಾಡಿದ್ದನ್ನ ಮುಂದೆ ಬರ್ತಕ್ಕಂಥವ್ರು ಅದನ್ನ ಸರಿಯಾಗಿ ವಿವರಿಸಲಿಕ್ಕೆ 63 ಜನ ಪ್ರಯತ್ನ ಪಟ್ಟಿದ್ದಾರೆ. ಇಂಥ ಒಂದು ವಿಜ್ಞಾನೇಶ್ವರನ ನಾವು ನೆನಪು ಮಾಡ್ಕೊತಾ ಇದ್ದೇವೆ. ಬೆಳಗ್ಗೆ ಇವತ್ತ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಕಲಬುರಗಿ ಪೀಠದ ಹಿರಿಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದ ಶ್ರೀನಿವಾಸ್ ಹರೀಶ್ ಕುಮಾರ್ ಅವರು ನಮ್ಮ ಜೊತೆ ಇದ್ರು. ಹಾಗೆ ಕಲಬುರಗಿ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಾದಂತ ಮಾನ್ಯ ಯಶವಂತ್ ಗುರುಕರ್ ಅವರಿದ್ರು. ಹಾಗೆ ನಮ್ಮ ಅಧ್ಯಕ್ಷರಂತ ಶ್ರೀ ಬಸವರಾಜ್ ಪಾಟೀಲ್. ಬೆಳಗ್ಗೆ ಹೇಳ್ಬೇಕಾದ್ರೆ ನಾನು ಹೇಳುದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಇಂಡಿಯಾ ರಿಪ್ರೆಸೆಂಟ್ಸ್ ಥಿಂಗ್ಸ್ ಏನಿದೆ ಅದನ್ನೆಲ್ಲ ಬಂದಿದೆ. ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಶಾಸಕಾಂಗ, ಕಾರ್ಯಾಂಗ ಮತ್ತು ನ್ಯಾಯಾಂಗದ ಪ್ರತಿನಿಧಿಗಳು ಇಲ್ಲಿ ವೇದಿಕೆ ಮೇಲೆ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿ. ಶಾಸಕಾಂಗದ ಪ್ರತಿನಿಧಿಯಾಗಿ ಮಾನ್ಯ ಶ್ರೀ ಬಸವರಾಜ್ ಪಾಟೀಲ್ರು, ನ್ಯಾಯಾಂಗದ ಪ್ರತಿನಿಧಿಗಳಾಗಿ ಮಾನ್ಯ ಹರೀಶ್ ಕುಮಾರ್ ಅವರು, ಕಾರ್ಯಾಂಗದ ಪ್ರತಿನಿಧಿಯಾಗಿ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಶ್ರೀ ಯಶವಂತರವರು ಇದ್ರು. ಇದೊಂದು ಅಭೂತಪೂರ್ವ ಅವಿಸ್ಮರಣೀಯ ಘಟನೆಯಲ್ಲಿ ಬಂದಂತರಿಗೆ ಎಲ್ಲರಿಗೂ ಕೂಡ ರೋಮಾಂಚನವಾಗೋ ರೀತಿಯಲ್ಲಿ ಕಾರ್ಯಕ್ರಮ ನಡೀತು. ಇದು ಕೇವಲ ಇಷ್ಟೇ ಆಗ್ಬಾರ್ದು, ಎಲ್ಲ ಕಡೆ ಹೋಗ್ಬೇಕು, ಭಾರತೀಯ ಧರ್ಮಶಾಸ್ತ್ರವನ್ನ ಅಧ್ಯಯನ ಆಗ್ಬೇಕು, ಪ್ರಸ್ತುತ ಸನ್ನಿವೇಶಕ್ಕೆ ಅದನ್ನ ಸರಿ ಆಗ್ಬೇಕು ಅನ್ನೋ ದೃಷ್ಟಿಯಿಂದ ವೆಬಿನಾರ್ ಇಟ್ಕೊಂಡಿದ್ರು. ಇದು ವೆಬಿನಾರ್ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿದೆ ಅನಿವಾರ್ಯವಾಗಿ, ಯಾಕಂದ್ರೆ ಅವರು ಇಂಗ್ಲಿಷ್ ಅಲ್ಲೇ ಮಾತಾಡ್ತಾರೆ. ಅವರಿಗೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ದೇವೆ ಹಿಂದಿಯಲ್ಲಿ ಕೂಡ ಮಾತಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ದೇವೆ. ನಾನು ನಾಡಗೌಡರನ್ನ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೋತೇವೆ, ಎಲ್ಲೆಲ್ಲಿ ಸಂದರ್ಭ ಸಿಕ್ಕರೆ ಅಥವಾ ಯಾರಾದ್ರೂ ಮೆಸೇಜ್ ಅಲ್ಲಿ ವಿವರಣೆ ಕೇಳಿದ್ರೆ, ಕೇಳೋರೆಲ್ಲರೂ ಮೆಸೇಜ್ ಅಲ್ಲಿ ಹಾಕ್ಬೋದು, ಅದ್ರ ವಿವರಣೆಯನ್ನ ಕನ್ನಡದಲ್ಲಿ ಕೊಟ್ರೆ, ಯಾಕಂದ್ರೆ ತುಂಬಾ ಜನ ಕನ್ನಡದ ವಿದ್ಯಾರ್ಥಿಗಳಿದ್ದಾರೆ. ಅದೇ ರೀತಿ ಸೆಂಟ್ರಲ್ ಯೂನಿವರ್ಸಿಟಿ ಅವರು, ಬೇರೆ ಬೇರೆ ಭಾಷೆಯವರು ಕೂಡ ಇದ್ದಾರೆ. ಸೊ ಹಿಂದಿ ಇಂಗ್ಲಿಷ್ ಆದ್ಮೇಲೆ ಅವಶ್ಯ ಬಿದ್ದಲ್ಲಿ ನಾಡಗೌಡರು ಅದನ್ನ ಕನ್ನಡದಲ್ಲಿ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಮಾಡ್ಬೇಕು ಅಂತ ನಾನು ಅವರಲ್ಲಿ ವಿನಂತಿಸಿಕೊಳ್ತಾ, ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಸಹಕಾರ ನೀಡಿದಂತ ಎಲ್ಲ ಕೈಗಳಿಗೂ, ಅಲ್ಲಿರ್ತಕ್ಕಂಥ ಎಲ್ಲ ಮನಸ್ಸುಗಳಿಗೂ ನಾನು ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನದ ಪರವಾಗಿ ಮತ್ತೊಮ್ಮೆ ಅಭಿನಂದನೆಗಳನ್ನ, ಧನ್ಯವಾದಗಳನ್ನ ತಿಳಿಸ್ತೇನೆ. ನಾವೆಲ್ಲರೂ ಕೂಡಿ ಒಟ್ಟಾಗಿ ಸನ್ಮಾನ್ಯ ಡಾಕ್ಟರ್ ರಾಮಾಜೋಶ್ವರ ಕನಸನ್ನ ಆ ನ್ಯಾಯಾಂಗ ವ್ಯವಸ್ಥೆಯಲ್ಲಿ ಭಾರತೀಯ ಪರಿಪ್ರೇಕ್ಷೆಯಲ್ಲಿ ಬದಲಾವಣೆಗಳನ್ನು ತರಲಿಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡೋಣ. ಭಾರತದ ನ್ಯಾಯಾಂಗ ವ್ಯವಸ್ಥೆಯನ್ನ ಜಗತ್ತಿಗೆ ಪರಿಚಯ ಮಾಡಿಸಕ್ಕಂತ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ನಾವು ನೀವು ಜೊತೆಯಾಗೋಣ ಹೇಳ್ತಾ ನನ್ನ ಮಾತುಗಳಿಗೆ ವಿರಾಮ ನೀಡ್ತೀನಿ. ಮಾನ್ಯ ಶ್ರೀ ಬಸವರಾಜ್ ಪಾಟೀಲ್ ಸೇಡಂ ಅವರಿಗೂ ಉಳಿದರೆಲ್ಲ ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಮಾತಾಡೋದ್ರಿಂದ ಕನ್ನಡದಲ್ಲಿ ಮಾತಾಡ್ಲಿಕ್ಕೆ ವಿನಂತಿಸಿಕೊಳ್ತಾ ನನ್ನ ಮಾತುಗಳಿಗೆ ವಿರಾಮ ನೀಡ್ತೇನೆ. ಭಾರತ್ ಮಾತಾ ಕಿ ಜೈ, ವಂದೇ ಮಾತರಂ.
ಧನ್ಯವಾದ ಶ್ರೀ ಮಹದೇವಯ್ಯ ಕರದಳ್ಳಿ ಅವರಿಗೆ. ನಾವು ಐ ರಿಕ್ವೆಸ್ಟ್ the chairman of this webinar, Shri Baswaraj Patil Sedam ji, to address the inaugural speech. Now unmute ಮಾಡಬೇಕಂತ ವಿನಂತಿ. Kindly unmute that. Sir, you are not at on.
आज के ऐतिहासिक दिन विज्ञानेश्वर द्वारा रचित मिताक्षर विज्ञानेश्वर द्वारा रचित मिताक्षर, उसके आधार पर कानून और कानून की आचरण, इन दोनों विषयों पर और दुनिया के जो प्रचलित वसाहतु व्यवस्था है, कॉलोनियल सिस्टम है, इन दोनों के बीच में एक किस प्रकार का अंतर और सामरस्य है, इसके बारे में एक तुलनात्मक अध्ययन के दृष्टि से ये 3 दिन का सेमिनार आयोजन किया गया है। पहले दिन के सेमिनार में आदरणीय श्री कृष्णन वेंकट रामन जी अपना विचार रखेंगे। आदरणीय सुरेश नाडगोड़ा जी इस समय प्रिसाइड करेंगे और आदरणीय जस्टिस रामा जोइस द्वारा प्रारंभ किया हुआ ये प्रकल्प उनकी मन की एक वेदना थी कि उसके बारे में उन्होंने कई किताब लिखी है कि भारतीय न्याय व्यवस्था इस विश्व के अंदर एक अत्यंत सुंदर न्याय व्यवस्था है, एक अच्छी जीवन के लिए, जिंदगी के लिए। दुर्भाग्य से उसको दुनिया के ऊपर और अपने देश में भी हम उसको प्रस्फुटित करने में असफल हुए हैं। इस निमित्त ये 3 दिन का जो सेमिनार चलेगा, एक प्रकार से उस दिशा में प्रवेश करने के लिए और हमारी ये व्यवस्था और विश्व को जानकार देने के लिए और अपने देश की एक अच्छी विकसित देश न्याय परंपरा के अंदर बनाने की दृष्टि से 3 दिन का यह कार्यक्रम अत्यंत यशस्वी हो। इसमें भाग लेने वाले सभी गण्यमान्य व्यक्तियों को, विशेषकर कल के भविष्य निर्माण करने वाले छात्र छात्राएं जो इसमें उपस्थित है, मैं उन सबको स्वागत करते हुए बहुत संतोष से मैं इस कार्यक्रम को प्रारंभ करने के लिए विनंती करते हुए मेरी शुभकामनाएं समर्पित करता हूं।
श्री बसवराज सेडम जी, उनको बहुत बहुत धन्यवाद। नाउ मे आई रिक्वेस्ट द speaker, today's honorable speaker, Shri Krishnan Venkatraman, to address his talk to the audience. And thereafter, there will be a short question and answer session. And then we will have the presidential remarks. And at the concluding portion will be the vote of thanks for today. And this program will continue even tomorrow at the same time. So, Mr. Krishnan Venkatraman, sir, please take the lead now. Thank you.
Namaste. I convey my sincere gratitude to the Vijnaneshwara Pratishthan who have invited me to have a discussion with all of you regarding this very topical issue. I consider it a very topical issue of knowledge of Vijnaneshwara's writings in the first hand. That's the scope of today's and tomorrow's discussion. Convey my respects to the honorable justices who are present here today, to the learned senior advocates, colleague advocates, and educators who have joined today to have a first-hand look at how Vijnaneshwara, around 900 years ago, I believe Shri Mahadevaya had mentioned that it is 900 years, 900 वर्ष समाप्त हो गए जब से विज्ञानेश्वर ने अपने वक्तव्य को प्रस्तुत किया था राजा विक्रमादित्य के समय पर। उसके पश्चात हम अभी ये देखना चाहेंगे कि विज्ञानेश्वर स्वयं एक विकसित स्थिति में थे। He was himself in a very advanced stage of thinking, and Vijnaneshwar in the Mitakshara has provided a gloss or a commentary on a previously existing text of Yajnavalkya Smriti. So Yajnavalkya himself was more than 2,500 years ago. That is some of the accepted period when he was there. And from then onwards, there has been a significant churn, because any legal understanding has to have contemporary value to society. So every society, every contemporary period, every time and every place has produced various scholars from time to time in the form of Narada, Brihaspati, etc. So many writers have written even before Vijnaneshwara. And Vijnaneshwara himself has done a samanjasya. उन्होंने बहुत सारे पिछले ग्रंथकारों के विषय पर चिंतन करके अपने वक्तव्य को प्रस्तुत किया है. What we have to understand, I believe, is that this itself is a dynamic process. And although the learned organizers have mentioned me as a scholar, I am but a student. I should let everybody know that I am myself a very humble beginning student of Sanskrit literature, especially Dharma Shastra. And I have just started making my first few steps into this subject. And it is only by way of a pilgrimage that I wanted to visit Martur, because I happened to have access to the book which was edited by Justice Rama Joyce, which is published by the Tirupati Rashtriya Samsthan, Sanskrit Samsthan, where he has given a very beautiful foreword and a description of the inauguration of the Martur Bhavan. So, drawn by his descriptions, I came to Martur a month and a half ago, and that was when, through Professor Devidas Male, I had been introduced to various other stakeholders in this project of trying to keep alive the memory and the activities of Vijnaneshwar. So today, without much ado, I would like to come to the topic. The whole purpose of this 2 or 3 day webinar was to sensitize all those interested directly to the writings of Vijnaneshwar. And while we get introduced to the writings of Vijnaneshwar, we have to keep in mind, हमें ये ध्यान में रखना चाहिए कि उनके विचार अब से प्रायः 1000 साल पहले के थे. उस समय के समाज के, उस समय के परिवेश के अनुसार उनका लेखन था. And it is our job as legal thinkers to understand the basic principles that are enlightened, which are brought out in his writings, and those have to be clothed in what is most appropriate for today's society. So we cannot judge himself based on today's society's norms, but we have to understand the basic principles of law that he has brought out in his writing, and see how we can be inspired by it and how we can adapt what is possible for today's practice. And I want to share with you the text. So this is I hope it's all visible.
Yes, sir, it is visible now.
So it's a fairly large. So this is part of the Yajnavalkya Smriti, which is one of the primary texts of the Dharma Shastra. The Yajnavalkya Smriti itself has multiple chapters. The first chapter deals with achara, or how a person ought to conduct himself. कैसे आचरण होना चाहिए एक युक्त पुरुष का. And it ends, the last portion of the first chapter of the achara deals with Raja Dharma Prakarana. It talks about Raja का आचरण कैसा होना चाहिए, एक अच्छे राजा का आचरण कैसा होना चाहिए. And Raja is supposed to be somebody who has been appointed to be the to have the responsibility for a society. एक समाज के देखभाल के लिए जिसके पास उत्तरदायित्व मिला है वही राजा है. And as one of the important aspects of a Raja's duties, there is description of Vyavahara. Because today we are dealing with Vyavahara, which is the second and the more voluminous chapter of the Yajnavalkya Smriti, which has been commented upon by Vijnaneshwara. So Vyavahara is the second chapter. So Atha Vyavahara Dhyaya and Vyavahara Matrika Prakaranam. Now we are looking at the first chapter. The first portion of this chapter begins with a template for dispute resolution. So Vyavahara is nothing but dispute. We will come to the definition of Vyavahara. Vyavahara is dispute, and any dispute which has a bearing on society, which has to be brought to the notice of the Raja or the ruler, has to be dealt with in a particular procedural manner, and it has to have a certain framework. तो उस व्यवहार के निष्पादन के लिए, व्यवहार के समाधान के लिए, व्यवहार जो समस्या है, दो व्यक्तियों के बीच में जो विवाद है, उस विवाद के समाधान के लिए जो प्रक्रिया है, उस प्रक्रिया का मूल इस व्यवहार मातृका में है. This is the template. Further descriptions use this template for solving specific types of disputes. So this is an introduction to disputes, dispute resolution, and the process of dispute resolution, we believe, as it existed at least prior to the disruptive effect of the colonial rule. Of course, subsequent to that, we seem to have forgotten some of these procedures, but it will be good to have a look at what and how dispute resolution used to take place, because we have to keep in mind that without the effective resolution of dispute, there could not have been a successful society. And we have been taught time and again that at various points of time, Indian society has attained the pinnacle of success in the Committee of Nations. So we have been mentioned as having a fairly large share of the world's GDP. And that would never necessarily have involved a disciplined society. And discipline in society has to come from the effective resolution of disputes in society. Because if disputes are allowed to fester, it will lead to a chaotic society. So the fact that we had a disciplined, successful society time and again means that we had an effective means of dispute resolution within the society. And it is this means of dispute resolution in society right from the time of Yajnavalkya's Smriti, which has gone through various evolutions. बहुत सारे उसमें परिवर्तन और विचारधाराओं में स्फुटन हुआ है, और उसके पश्चात अभी हमारे पास याज्ञवल्क्य स्मृति के विज्ञानेश्वर के उक्त मिताक्षरा का टीका है, discussion on the Yajnavalkya Smriti. And the starting of it, so the point is to sensitize all of you to the text of the mitakshara is the purpose. Abhishekadi guna yuktasya prajapalanam paramodharma. So this is the introduction by Vijnaneshwara. The Vijnaneshwara, who was a scholar commissioned by Vikramaditya, sitting in Martur, as we now know, 900 years ago, has started his commentary or his extensive essay on dispute resolution by these words. These are the words of Vijnaneshwara himself. Abhishekadi guna yuktasya prajapalanam paramodharma. So the first and most foremost dharma or duty of the ruler or any leader who has the responsibility for society, जिसके पास समाज के नेतृत्व का उसके लिए जो उसको करना है, उसका जो कर्तव्य है, जिसके कंधे पे है, वही राजा है. और उस राजा जिसको अभिषेक आदि गुणों से, ये तो संस्कार हैं, these are the various samskaras by which a person has been appointed and dedicated to society as a raja. His primary dharma is prajapalana, because some interesting questions that are facing our present society in terms of whether we should have a division of the powers in terms of executive, legislative, judiciary, or whether they should be in one person, how they should be divided, etc. Some of these questions have also occupied the minds of various thinkers in the past, because they had to deal with similar civilized society. And they have come up with their viewpoints, and it will be instructive to see what they have to say. So, Abhishekadi guna yuktasya prajapalanam paramodharma. Prajapalanam is the first duty. Tacha dushta nigraham antarena na sambhavati. This, just to give you a sense, this is the text by Vijnaneshwara, followed by a discussion on Vijnaneshwara's writing in a text called Subodhini and Palam Bhatti. We will not go into that detail, but all of this is available in this text, which is published recently by the Rashtriya Sanskrit Vidyapitha. And those who are not able to read Sanskrit directly, they are well advised to also read this text, Legal and Constitutional History of India by Justice Rama Joyce. So he has himself spent a lifetime understanding these various subjects. And for our benefit, along with the Sanskrit original texts, he has given his discussions in English. So that's a good place to start reading. He has also provided an introduction to the Sanskrit book as well. I'm sure he is a scholar of Sanskrit also. So, tacha dushta nigraham antarena na sambhavati. So, importantly, prajapalanam, that is the protection of the interests of society. Samaj ki हितों के रक्षा के लिए जो राजा का उत्तरदायित्व है, उसके लिए मुख्य कारण है दुष्ट निग्रह. जो दुष्ट जन है, जिनके कारण समाज में उद्वेग, जिनके कारण समाज में द्वेष आदि जो अनिष्ट गुण उत्पन्न हो सकते हैं, उनका निग्रहण, they have to be punished and they have to be, to the extent possible, isolated from society. That's what law sets out to do. So the defaults, the defaulters, so to say, of society, of social in society, have to be punished, to be sensitive. have to be identified and punished. Dushta parigyanam chana vyavahara darshanena vineti sambhavati. That aspect of ensuring that those defaulters or defaulting individuals are identified and punished, that cannot be done without a due process. And that due process is called vyavahara darshanam. Dushta parigyanam chana vyavahara darshanena vina sambhavati. Without proper process of establishing who is right, who is wrong, who is the dushta, we cannot go ahead for prajapalanam. So the basis of prajapalanam is dushta nigraha, and dushta nigrahanam is based on vyavahara. Tad vyavahara darshanam aharaha kartavyam. Ahaha is day. Every day without fail the king has to make sure that this vyavahara darshanam is done, because every day there are going to be defaults in society, and it is the king's duty or the ruler's duty to ensure. So in a sense, we get a sense of there being the legal administration is also in the hands of the executive. We get that sense when you go through this. Tad vyavahara darshanam aharaha kartavyam ityuktam. Vyavahara darshanan swayam pashyet sabhyaif parivritavan vaham. So this is the requirement. In the previous chapter in Raja Dharma Prakaranam, it has already been mentioned that every day, along with sabhyas, along with the committee of educated persons, the ruler has to ensure that vyavahara is, or judicial administration is done. Such a vyavahara kidrishaha katividhaha katham cheti iti kartavyata kalapo nabhihidaha. In that chapter, they have not discussed about the details of what is vyavahara, what is the nature of vyavahara, how are disputes, what kind of disputes can exist, and how those disputes have to be resolved. That has not been mentioned there. So that is, this chapter is devoted to that. Tad abhidhanaya dvitiyo adhyaya prarabhyate vyavahara niti. So the second chapter, दूसरा जो अध्याय है वो व्यवहार के प्रकार, व्यवहार के लक्षण, के व्यवहार क्या है यह समझने के लिए, और व्यवहार के होते हुए, व्यवहार तो होंगे ही, व्यवहार का अर्थ है विवाद, समाज में विवाद होंगे, और उन विवादों का समाधान के लिए क्या करना है और कैसे विवादों का निष्पादन करना है, वो इस अध्याय में, द सेकंड चैप्टर, इट इज बीइंग डिस्कस्ड. So the first, this is the first metric verse. So याज्ञवल्क्य ने अपने याज्ञवल्क्य स्मृति को छंदोबद्ध किया है. उन्होंने उसको पद्य रूप में लिखा है, गद्य रूप में ही लिखा है. यहाँ पे मिताक्षरा तो गद्य में है. मिताक्षरा is like an essay, whereas the original on which it is commenting, the याज्ञवल्क्य स्मृति itself is in a metric form. व्यवहारान् नृपः पश्येत् विद्वद्भिर् ब्राह्मणैः सह धर्मशास्त्रानुसारेण क्रोध लोभ विवर्जितः. So this is the first text, first shloka or the verse of this Yajnavalkya Smriti. Vyavaharan nripah pashyet. The king has to make sure that all disputes are looked into. Pashyet. Vidvadbhir brahmanes, ब्राह्मणों के साथ जो विद्वान जन हैं, उनके साथ बैठ के उनको विवादों का जो है निदर्शन करना चाहिए. धर्मशास्त्र अनुसारेण, और उसका धर्मशास्त्र के अनुसार उन विवादों के निष्पादन हेतु प्रयास करने चाहिए राजा को. क्रोध लोभ विवर्जिता, और राजा को किस बुद्धि, किस चित्त की अवस्था में उसको ये सब करना चाहिए. दैट इज क्रोध और लोभ. दीज आर द वेरियस corrupting influences on the mind of any person who is going to decide what is right and wrong. That is krodha and lobha. Those have to be ensured as being absent from the mind or the intellect or the consciousness of the person who is looking into vyavahara. So that is being now discussed. So each verse of Yajnavalkya is being discussed by Vijnaneshwara. Anya virodhena swatma sambandhitaya kathanam vyavahara. So first definition of what is vyavahara is coming out here. Anya virodhena. So when a person, a complainant or a plaintiff comes to an institution that is to deal with judicial administration, he comes with having a complaint. He has something to say about somebody else. Anya virodhena swatma sambandhitaya. It also gives you a sense that there has to be a locus standi. The person has to, who is raising the dispute, he has to have some reason to raise the dispute. He has to have a locus standi to come to the place of judicial administration. Swatma sambandhitaya anya virodhena kathanam. That raising of a complaint is called vyavahara, a dispute. bringing up of a dispute in the first place is called a vyavahara. Yatha kaschid, he's giving a simple example because the method of writing by Vijnaneshwara, to the extent that I have been accustomed to his reading now after having gone through some of these texts, he has a very clear-cut writing. He doesn't try to be very, he doesn't try to show his own academic prowess or anything. His aim is to reach the person with the most basic understanding and to explain. That is his method of writing. Very simple, very direct. And one thing you can make out, he has a very compassionate manner of trying to look at society. He tries to reach out to those who have been, who don't have the means. So in the sense, his outlook is compassionate, because this is especially so, you can make out this विज्ञानेश्वर के कृपा पूर्वक लेखन का हमें इसलिए हमें पता लगता है क्योंकि अन्य जो टीकाकार हैं जिन्होंने याज्ञवल्क्य स्मृति के टीका लिखे, कुछ लोग बहुत ही, some people are very they just go by the words and the meanings. They are very direct in their interpretation, whereas Vijnaneshwara we find has a more people-centric, creative method of it, of interpreting the texts. Yatha kaschididam kshetradi madiyamiti kathayati anyopi tad virodhena madiyamiti. So a simple explanation of what is vyavahara. One person says kaschid, somebody says kshetradi, some piece of land, property. He says madiyam, this is mine. Another person challenges that statement and says anyo tad virodhena, in a challenging way says madiyam. So two people have a dispute with regard to an entity here, immovable property. That becomes a simple definition of what is vyavahara. Tasya aneka vidatvam darshayati bahuvachane. There can be many types of disputes. Aneka vyavaharan. Nrupa iti na kshatriya matrasya ayam dharmaha kintu prajapalana adhikritasya anyasyapi iti darshayati. So this is Nrupa. The word Nrupa is not only limited to kshatriyas, but any person in a position of responsibility towards the well-being of society. Prajapalana adhikrita, जिसका अधिकार है प्रजा के पालन हेतु. Somebody who has to ensure the well-being of society and the taking care of society's interests. Such a person has got the responsibility to ensure that disputes, if they arise, have to be dealt with immediately. Adhikritasya anyasya. It also gives you a sense of who has the locus for ensuring that judicial administration is effective in the perspective of Vijnaneshwara. Pashyed iti purvoktasya anuvado dharma vishesha vidhanartha. It has already been mentioned in the Raja Dharma Prakaranam. It is also being repeated here. Vidvadbhihi. So who are the vidvans? The person who is eligible to be part of the committee has to himself be fairly well educated in certain types of subjects. So Veda, Vyakaranadi, Dharma Shastra Vijnaihi. So person who has indulged in the or involved with the study of Vedas, and Vedas is nothing but the study of the Brahman or the nature of reality or what binds everybody. So a person who has attempted to grapple with the intent of the Veda, Vyakarana, how to bring out correct language. The person, because especially in legal administration, language has to be precise. Vyakaranadi, Dharma Shastra, then person who has indulged in the study of dharmas, etc., Dharma Shastra, Abhijnahi, Brahmanair, Nakshatriya. So, of course, as I mentioned, this is a product of a society around 1000 years ago, and we have to take it for what it is. And of course, we should not be judging against the standards of present society, but it is his viewpoint that it is only people who have engaged in this or who have progressed in education up to that extent and who are Brahmanas are qualified to be the committee, part of the committee of the judicial administration. Brahmane saheti tritiya nirdeshat tesham apradhani. Now, what is important is he says, since they are only supporting members, the word the tritiya, that particular vibhakti is used, it shows that they only play a supportive role. The members of the committee who advise the ruler when he is in his position as a magistrate or as a justice dispensator, they only play a apradhana. उनका काम प्रधान नहीं है, उनका स्थान अप्रधान ही है. जो राजा है, जो मुख्य है, जो प्रजा पालन के काम में अधिकृत है, उसका ही मुख्य कर्तव्य है कि विवादों का और इन विषयों का जो है निष्पादन हो. सहयुक्तेति अप्रधाने अतः च अदर्शने अन्यथा दर्शने च Rajnyo doshaha na brahmanana. So if there is an error, if there is a miscarriage of justice, यदि न्याय के निष्पादन में कहीं च्युति हो गई हो, उसका दोष राजा को पर ही जाता है. The person who is in charge of ensuring that society's well-being is maintained, it becomes his default and not the default of the advisors per se. So that he has the buck stops with the Raja, so to say. Tatha ahamanuho adandyan dandayan Raja dandyan shaivapya dandayan ayasho mahadapnoti arakam chaiva gachati. So a person, a Raja who does not punish those who deserve punishment and who punishes those who otherwise don't deserve punishment. So therefore, miscarriage of justice, if that occurs, such a Raja suffers ayasha. He becomes, he does not get yasha. He does not become well known. He gets a bad reputation, so to say. He loses reputation in society. And of course, from the point of view of Dharma Shastra, he also attains naraka. That means naraka is something that is absolute unhappiness, no joy at all. Swarga is pure joy. Naraka is pure unhappiness. So he attains that state of being miserable, the Raja, if he engages in bad administration of the iti. Dharma Shastra anusarena na Artha Shastra anusarena. Deshadi samaya dharmasyapi Dharma Shastra aviruddhasya Dharma Shastra vishayatvan na prathak upadana. So another aspect is Dharma Shastra only talks about specific aspects of dharma, which are mentioned in Yajnavalkya Smriti and in these classical texts. But he also mentions, Vijnaneshwara expands the definition of Dharma Shastra to also include what is prevalent social conduct. So he talks about Deshadi Samaya Dharma. So if there is any valid conduct in a particular society, which is otherwise not mentioned in writing so explicitly in Dharma Shastra, that also becomes automatically a subject matter of Dharma Shastra. Deshadi Samaya Dharmasyapi Dharma Shastra aviruddhasya, as long as it does not contradict Dharma Shastra, Dharma Shastra vishayatvam. It is subject matter of the Dharma Shastra. Prithak upadana. It's not separately mentioned. Yatha cha vakshyati nija dharma virodhena yastu samayiko bhavet sopi yatnena samrakshyo dharmo rajakritashchaya. So these are the various aspects of social conduct which have to be protected by judicial administration. Those include Nija dharma virodhena. If there is a Dharma Shastra which is explicit or written, so to say, whatever is not against that and is prevalent in society, that also has to be protected. That conduct also has to be acknowledged as being a valid basis of justice administration. And so yatnena samrakshya, that social structure also has to be protected to the extent possible. And dharma rajakritashchaya. So Raja will also make some dharmas. He will make his own statutory declarations as to from this day onwards, this will be the rate of taxation, or this will be the nature of conduct that is required for his jurisdiction. That is also to be included as a source of dharma. So Dharma Shastra anusarena iti siddhe krodha lobha vivarjita iti vachanam adarartham. Although they have already said the administration of justice has to be in line with dharma, or dharma Shastra, which includes Samaya Dharma or Desha Dharma. So when you say that you have already fixed the area in which to operate, in which the mind of the judicial administrator has to operate, even then for additional understanding, they have said it should be krodha lobha vivarjita. So krodha is amarsha. So one should not be prejudiced against, especially the subject matter of dispute, while being an administrator of dispute in that particular context. And lobha is lipsati shayaha, having excessive greed. So with that kind of an attitude, one cannot be expected to be an effective judicial administrator. So this is the first verse and the explanation by first verse of Yajnavalkya Smriti and its explanation by Vijnaneshwara. That's the. I'll request if the organizers, is this a good time to have a pause? I mean, so that we have some discussion and so today we continue further because.
Sir, you have been speaking for last 20 minutes hardly. So it is your discretion because the Honorable President also may speak and you can also have a question and answer session if you wish to pause here. We still have another, at least it's now 6:20. up to 6:45 we will have this session, today's session. So you may continue for another 5 to 6 minutes, so that thereafter the honorable there will be a question and answer session, and then the honorable.
It is better once for all you please complete, sir. Then we can have a question and answer session.
Fine, sir. Yeah. We will. So that was the first. The second verse in the Yajnavalkya Smriti is Kincha Shrutadhyayana Sampanna Dharmajna Satyavadina Rajna Sabhasadah Karya Ripau Mitre Cha Ye Samaha. So this is the second verse where in stages Yajnavalkya had described 2500 years ago, of course, about the process and the code of how judicial administration has to be ensured. The first part of it is the Raja himself and his Raja का ही कर्तव्य है, मुख्य प्रजापालन नियुक्त जो पुरुष है, व्यक्ति है, उसका ही काम बनता है विवादों के समाधान के लिए जो प्रयत्न करना, और उसके लिए उसके पास सभासद होने चाहिए. He should have his members of committee that is dealing with judicial administration. So what is the qualification of members? So today, of course, we talk about academic qualifications when we talk about committee members, etc. Here, of course, it's the qualification are more with respect to their nature and how their personal traits are. So some of them are academic. Shrutat Chayana Sampanna. So they should have had sufficient opportunity to engage with Shruti, which is the Veda, and Adhyayanam, and the related subjects related to the Vedas. So they should have had an academic bent of mind, so to say. Adhyayana Sampanna, Dharmajna, and they should have contemplated on nature of Dharma, because Dharma is very difficult to catch. What is right and what is wrong, even the greatest of poets or scholars had always found it difficult to know. So they should have engaged their mind with questions of Dharma. Satyavadinaha, they should have a tendency to speak truth, not deceit. Rajna Sabhasadah Karya, these kind of persons can be chosen for inclusion in his Sabha. In this case, Sabha is for dispute resolution, committee of dispute resolution Karya. Ripau Mitre Chaye Samaha. So उनको रिपु का अर्थ शत्रु और जो मित्र जन है, जो उनके सुहृद जन है, उन दोनों के प्रति उनके मन में कोई भेदभाव नहीं होना चाहिए, उनके प्रति उनका समभाव होना चाहिए. So they should not be influenced by thoughts of affinity or dislike. They should be able to take decisions in an unprejudiced manner. So these are the words of Yajnavalkya, followed by discussion in his essay form by Vijnaneshwara. Shrutena Mimamsa Vyakaranadi Shravanena. This is what they should have learned is Mimamsa. Mimamsa is the particular learning that talks about interpretation. There, of course, interpretation of the Vedas, but that is also useful for interpretation of any texts, the use of Mimamsa. In fact, some of our learned members of the Honorable Supreme Court judges, especially Justice B.N. Shri Krishna, he himself had been a great scholar of Mimamsa and has dealt with at length on the application of certain Mimamsa methods to interpretation. So Shrutena Mimamsa, then Vyakarana, which is the correct usage of language, Adi Shravanena. So they should have applied their minds to these subjects. Adhyayanena, Vedadhyayanena. So they should have applied themselves to the intent of the Veda, which itself is an uplifting activity. So they should have engaged in that. Adhyayana Vedadhyayanena cha Sampannaha. Dharmajnaha. They should have applied their mind to the workings of Dharma. Dharma Shastrajnaha. Also how Dharma Shastra functions. They should have read various. So this is one commentary. There are numerous commentaries on these Dharma Shastras. This is only one Dharma Shastra. There are numerous Dharma Shastras. So it's a multi-variegated kind of a academic field itself. Satyavadinaha, Satyavadana Shilaha. So Satyavadinaha means they should have a tendency to speak truth, not a tendency to speak untruth. At least that tendency should be there. Ripau Mitre Chaye Samaha, Dvesha Raga Rahita. So they should not be affected by either Dvesha or dislike or Raga, like Dvesha Raga Rahita. Evam Bhutaha, Sabhasadaha, Sabhayam, Samsadi, Yatha Sidanti, Upavishanti, Tatha Dana Satkarai, Rajna. So another important thing is such people are happy in their old world. They are happy doing their academic activities, are happy in their pursuit of whatever gives them joy. But those persons are especially useful for judicial administration because they have a certain bent of mind, certain kind of the ability to think about social circumstances. So the Raja is meant to invite them and give them the special privilege or whatever it takes in terms of dana, mana, satkara, either in terms of wealth, that is, they have to be properly provided for materially, mana, in terms of they should be given sufficient respect in society and in his presence, and satkara, these various aspects have to be taken care of, and they should be specially engaged in this aspect of judicial administration. Such people have to be identified and invited and suitably compensated to make it worth their while to be judicial administrators. Yadyapi shrutadhyayana sampanna ityavisheshanena uktam tathapi brahmana eva yataha katyayana satu sabhyaihi sthirair yuktah prajnair maudair vijottamaihi dharma shastrarthak shalair arthak shastra vishar. So people who have engaged in study of dharma shastra, artha shastra, usually I think in their in society at that point of time, since there was a classification of activities by various varnas, Kshatriyas would take care of administration, warfare, etc., Vaishyas. So it is expected that it would be at that in that time and space when Vijnaneshwara was writing, that it is more likely to get such people from the society of Brahmanas. That's what we can think of. Iticha te chatrayah kartavyaha. So it is also mentioned that, just similar to our even Arbitration Act, the members of the committee have to always be in odd numbers starting with 3. So it cannot be even numbers. So this is to avoid tied decisions. So te chatrayah kartavyaha bahuvachanasya arthatvat. Yasmin deshe nishidanti vipra veda vidastrayah. The Manu has also mentioned that people who have sufficient knowledge in the Veda and 3 of them sit together, it is a sabha, and that can be the basis of checking. Basically, a sabha is where you put in questions and get answers as to what is right and wrong. And it is that sabha is composed of 3 or more. The Brihaspati's to sapta pancha trayo va sabhasado bhavanti. So Brihaspati's opinion is that there should be either 7, 5, or 3 members of sabhas to make it a valid composition for a committee for the ruler to engage with for effective judicial administration. The Loka Vedagnya Dharmagnaha Sapta Pancha Trayopiva Yatropavishta Viprasya Sa Yagnya Sadrishi Sabha. So where these 3, 7, or 5 people get together who have sufficient knowledge of the Vedas and sit together for engaging themselves in solving a certain problem or a question that comes before them, that is equivalent to Yajna itself, Yajna Sadrishi Sabha. Iti Nacha Brahmani Sahiti Purva Shlokoktanam Brahmananam Shrutathyena Sampanna Ityadi Visheshanamiti Mantavyam Tritiya Prathamantar Nirdishtanam Visheshana Visheshya Bhavasambhavat Virityanena Punarakti Prasangacha. So there he is making out a difference between those who are merely there as to present as Brahmanas to advise the king, and some persons who are appointed. So there is a difference between a person who is merely available and engaging in the process and a person who has got appointed as a sabhasad. So there is a difference in their in what they are supposed to do in terms of, and what happens to them if they don't act effectively. Tathacha Katyayana Brahmananam sabhasadam cha spashtam bhedo darshita. Katyayana, another previous commentator, has made out the difference between a normal unappointed learned person, Brahmana, and an appointed learned person. There is a difference. Saprad vivaka samatyaha sabrahmana purohitaha sasabhyah prekshako raja swarge tishtati karmataha. So a raja is encouraged. Raja को ये प्रोत्साहन दिया जाता है कि वो जब समाज के कल्याण के हेतु सभा का नियोजन करे, उसमें प्राण विभाग is the chairperson, just as you have a presiding arbitrator or a chairperson in a committee. Prad Vivak is the chair. Prad Vivak Samatya, along with Amatyas, Sabbrahmanas Purohitaha. So he has to have an entire committee and then apply his mind in the presence of the committee personally. So that in a sense it also guides his ability to think correctly rather than thinking in a private space. Aniyuktaha Sabhasadastu Niyukta. The difference between Brahmana and Sabhasada is one is not appointed, one is appointed. And what happens? Ateva Uktam Niyukto Va Niyukto Va Dharmagnya Vaktamarhati तत्र नियुक्तानां यथावस्थित अर्थकथनेति यदि राजा अन्यथा करोति तदा असौ निवारणीयः अन्यथा दोषः. So the appointed person has got an additional responsibility to ensure that if the king, if the Raja or if the ruler is straying away from the path of dharma, he has he is required to stop that particular deviant action on the part of the ruler. Whereas a normal spectator Brahmana does not have that responsibility. So there he has an added responsibility since he has been appointed, he has been given a post, he has been given the satkara, dana, mana, satkara, etc. And he has been specially appointed for a post. He has a responsibility towards that post to ensure that even if the ruler acts in a deviant manner, he has to ensure that he stops the ruler from acting in such a deviant manner. Uktam chakatyayena anyayena pitam yantam yenu yanti sabhasatah tepi tadbhagyanas tasmad bodhaniyas satayandra. So once you are an appointed candidate, once you have been given a post, you have been given a salary, etc., it becomes incumbent on that person to ensure that he stops, because he's part of the process now. He's not merely a bystander, he is not merely a person who is giving free advice. He becomes part of the process, and anything that goes wrong with the process, he becomes responsible for that directly. Aniyuktanam punar anyatha vidane anabhidane va dosho natu rajnya. So if a person who is not appointed, who is merely there as a spectator or as a part of that sabha, he may or may not bring it to the point of attention of the ruler, and he does not suffer the consequences in terms of either dharma or society. Whereas a person who is appointed, who has a post, who has a particular responsibility, he has to ensure that that responsibility is fulfilled. Sabha va na praveshtavya vaktavyam va samanjasam abruvan vibruvan vapi naro bhavati. So he is very clear. He says, if you have been appointed to a sabha, either you don't go to the sabha, stay away from the sabha and say, I don't want to be a sabhasad. Once you have been appointed, और जब सभा में प्रवेश कर दिया हो किसी ने, तब उसको बोलना चाहिए केवल धर्मयुक्त. धर्म विरुद्ध बोल दिया या चुप रहा या राजा का निवारण नहीं किया जब राजा जो है दुष्ट मार्ग में प्रविष्ट हो रहे हो, तब उसका दोष बनता है. यदि उसको अपने आप में अपने शीलता पर विश्वास नहीं है, तो उसको सभा में प्रवेश ही नहीं करना चाहिए. सभा में प्रविष्ट करने के बाद उसको उसका धर्म का आचरण करना चाहिए, सभासद के धर्म का आचरण का पालन करना चाहिए. इति मनुस्मरणार्थ. त्रिपौ मित्रे चेति चकाराल लोकरंजनार्थम कतिपयैर वणिभिरधिष्ठितं सतः कर्तव्यम्. So in addition that Vijnaneshwara is mentioning that in the sabha, which is meant for judicial administration, there should also be certain businessmen, traders, vanik, who are experienced in certain aspects of trade, etc. They have to also be included as part of the sabha. Yatha Katyayana has mentioned, Kula Shila Vayovritta Vittavadbhir Amatsaraihi Vanikbhihi Syat Katipayahi Kula Bhutair Adhishtitam. So there should also be some, because various disputes will be involving various trades, certain specific subject matter specific disputes, etc. So there should also be persons who are sufficiently of age, who are of a good family, etc., and who are well off. They are not having any so that they might not be impacted by temptation, etc. Kula Shila Vayovritta Vitta Vadbhir Amatsaraihi, and they should also be Amatsara. They should not be prejudiced, unprejudiced. They should be Vanikbhihi. Such businessmen also should be included in the sabha for judicial administration. So this is a sort of the second step. First, the ruler himself, how he has to have certain qualities, and how his committee has to have certain qualities, and how without a committee he becomes less effective, and how he has to work with such a committee, and the committee members' responsibility, the sabhasada's responsibility as well, and the fact that various other subject experts and trade experts can also be included as part of the committee is sort of described in the second verse of the template, how a template for judicial administration has to be in a society ruled by a Raja. That is mentioned. So I think this is a good time, sir, to.
Sir, your explanation is mesmerizing us, and we actually would want and wish you to continue. There is I'm sure everybody wants to be attentive enough more. but then we are at 6:34 now. If I could request other participants to raise their hand and unmute themselves and pose any question at this stage, so that the honorable speaker might explain the doubts of the participants. This will continue for 3 to 4 minutes or 5 minutes maximum. Thereafter, I would request the honorable presider, Shri Suresh Nadagodu, to.
Just to point out, sir, I'm also so rather than my clearing the doubts, it also be an open discussion and people looking for their views also, sir, because there are
Yes.
more learned than me also.
In fact, the honorable justices are here and honorable retired justices are here. It would be really, we would welcome all of them to have their views also, air their views for the present webinar. Anybody may unmute, sir. You can raise the hand and the host will unmute you to pose a question to the speaker, so that the speaker or either other participants, learned participants. Yeah,
Not only questions, any additions also they can do.
So no questions from anybody? Any participants? Okay. So may I request our esteemed colleague, Dr. Jyoti Vishwanath, who has done her research on Vijnaneshwara's contributions, to raise any questions. And she is also teaching Hindu law and university law. Jyoti Vishwanath.
Yeah, yes, sir. Good evening, sir. Respected dignitaries present here. I hope I'm audible.
you are
Yeah,
audible.
you are audible.
Yeah. It was a very nice, knowledgeable course, sir, which has been started today. And whatever points sir has discussed, Krishnan sir has discussed. Actually, when he was displaying, he was giving the screenshot, we can see the whole text is in Sanskrit actually. Though it is a Sanskrit, with what ease he has discussed it, इतनी आसानी से उन्होंने संस्कृत टेक्स्ट को पढ़ा और उसे समझाया, ये बहुत ही प्रशंसनीय है. When I was doing my PhD in Mitaksha law, I had opportunity to visit Marthur. I had visited Marthur twice, once in 2004 and once in 2008. And at the time, I got lots of material relating to Hindu law in Marthur. And I also want to highlight that this Yajnavalkya Smriti, which sir was speaking and referring to, Yajnavalkya Smriti and Manu in Sanskrit as well as in English as well as in Hindi. I got all these texts in Oriental Institute of Bhandarkar Institute in Pune actually. So lots of material is available there. So कृष्णन सर ने आज जो भी बातें बताई हैं उससे एक बात बहुत ही स्पष्ट हो जाता है कि मिताक्षरा में जो भी राजधर्म के बारे में लिखा गया है वो ना सिर्फ भारत में बहुत ही इम्पोर्टेंट है, बल्कि इट्स लाइक अ टॉर्च बियरर फॉर ऑलमोस्ट all the countries of the world. Because when you see what is the duty of a king, what is the duty of a darbari, that is sabasad, उसकी क्या कर्तव्य हैं जब वो सभा में जाता है, तो जब हम ये सब सुन रहे थे तो लगता है जैसे कि इन सब चीजों, इन सब बातों की, इन सब का ज्ञान की जरूरत ना सिर्फ भारत में बल्कि दूसरे देशों में भी है. Because see, today we have a war going on between Russia and Ukraine. So they are also kings. So what they have to learn, I think we have to highlight Mitaksha more and more by these type of lectures, by these type of programs. So this is my view. This is my opinion regarding whatever Krishnan sir has spoken. My PhD research was on succession actually, succession and maintenance with special reference to Mitaksha. So anyway, I am very thankful to our principal, Professor Suresh Nadagodu sir, who thought that I can give some inputs in today's program. Thank you very much, sir. Thank you to the organizers also.
Thank you for your candid remarks, Dr. Jyoti. Anybody else? So if there are no other questions, may I request our another esteemed colleague, Professor Sudesh, who deals with jurisprudence, to give his remarks on the presentation of Sri Krishnan. Professor Sudesh, sir? I think, yeah, he's not there. Okay. He has left the meeting. Okay, he had some other. He informed me that he had another. He has another meeting. Okay, he might have gone there.
ಶ್ರೀಶಾಂತ್ ಸರ್ ಹ್ಯಾಂಡ್ ರೈಸ್ ಮಾಡಿದ್ದೆ ನೋಡ್ರಿ ಏನಂತೆ
ಯಾರು ಮಾಡಿದಾರೆ
ಸರ್? ಅಮಿತ್ ಅವ್ರೆ,
I would request the host to unmute his Lordship Justice, who is Rishanam.
Good evening. Am I audible?
Yes, sir, you're audible. Please.
Indeed, it was a wonderful lecture by Professor Krishnan. I had also been to Bhandarkar Oriental Research Institute when I was a lawyer. P.V. Kane has given us the best English translation on the history of Dharma Shastra. One point that I would like to add, of course, it is from the Manusmriti, which has seen the approval of the Honorable Apex Court in the case of Zahira Habibullah Sheikh, reported in EIR SC 2006, 1367. One can note this. In that, two stanzas of Manusmriti are quoted by His Lordship Justice Arijit Pasayat, wherein little background is necessary to appreciate how it is relevant even today. AIR 2006 SC, page 1367. 1367. It is the second best bakery case that one can easily remember. The first decision was in 2004, as you know, that after the post-Godra incident, there was a petition filed in the Supreme Court where they wanted that the case to be transferred from Gujarat to some other state, and incidentally that was transferred to Maharashtra, and then it was being tried. Zahira Habibullah Sheikh being the key eyewitness there, she has turned hostile to the case of the prosecution. There was a petition filed before the Honorable Apex Court. In that, the perjury, she was punished, and ultimately Zahira Habibullah Sheikh has to undergo 1 year imprisonment. We are not concerned with the merits of the matter there. What is to be looked into is how such people are to be dealt with was in Manusmriti itself. The two stanzas, which are the opening paragraphs in the judgment, I would not venture to give it in Sanskrit for paucity of time. Padau Dharma Hetyaraha is the one. And the earlier to that was the, if there is a injustice overtaken, when justice has overtaken the justice in a court of law, it is the Sabha Sadan who would get the sin, who would incur the sin is the first. Then how that particular sin is to be divided among the persons who are responsible for it. These are the two stanzas Justice Arijit Pasayat has quoted, and then deals with the case. We are only concerned with the two stanzas where the Raja Dharma, or the role of the judiciary in dealing with such things, was highlighted. One can be very interesting to note that if injustice or anyaya overtakes nyaya in a court of law, it is the king or the judge who incurs the sin. This is the first stanza. Second stanza is that if that sin is to be divided, it is to be divided into 4 parts. One quarter thereof is for the person who committed the offense. The next quarter would go to the person who has given a false evidence, and the next quarter would include all concerned in advocating a falsehood before the court, and last quarter will always be that of the judge. So the judge was made aware that, at any cost, one should not allow the injustice to overtake the justice in the court of law. This was taught even as per the Western jurists in the 3rd century. One can now compare this with the other modern texts. One would be surprised to note that Kenny, a Western jurist, a Britisher, wrote in his outlines of criminal law that Britishers were not knowing the definition of crime till the advent of 14th century. Vis-a-vis the 3rd century, we not only, Manu, defined the crime, but also classified into two, one for the sake of woman and others for the sake of the mother earth, the wealth. That is the wealth is from the mother earth. ಒಂದು ಹೆಣ್ಣಿಗಾಗಿ ಒಂದು ಮಣ್ಣಿಗಾಗಿ ಅಂತ ಬಹಳ ಸ್ಪಷ್ಟವಾಗಿ ಮನು ಕ್ಲಾಸಿಫೈ ಮಾಡ್ತಾರೆ in the 3rd century as per the Westerners. So one can now compare what was the level with which that our country had. We had not only a very sound judicial system to advocate and administer the cause of justice, but also it was very much codified. Krishnan has taken much pains onto the relevant aspects of the Yajnavalkya. We have wonderful English translations as well. Mitakshara, of course, deals with the commentary portion thereof. As Madam has put it, one would be only concentrating, being a lawyer, only with the succession and other aspects of the matter. But there are many other areas which are highlighted by Mitakshara while writing the commentary to Yajnavalkya Smriti. Yajnavalkya comes later to Manu as per the juries, and Yajnavalkya propounds further portions of what has been left over by Manu. Likewise, Narada Smriti, Parashara, all these things would be there. Even today, the people come to Oriental Research Institute, Pune, for missing pages than in their original text, which have been stolen away from this country. And one would be very much surprised that majority of the persons who visit the Bhandarkar Research Institute is the foreigners, and many Germans visit there. So one can note, one can find out what is the precious thing that we had, and unfortunately somewhere in between, maybe because of the so many invasions that has taken place on this country and so many cultural aberrations that have taken place over a period of several centuries, one may not be in a position to understand what exactly is the meaning that we had and what is the profound knowledge that we had, and somewhere we have lost it. Rash Bihari Ghosh in his work on the mortgages in 1800s has written that the harvest, the crop is ready for harvesting, but hardly he finds a single soul with a sickle to harvest the standing crop. If that was the situation in 1800 itself, we can understand, we can appreciate how bad today it is. It is the time that we need to revisit as a student of law to find out as to, I agree that today's angle, from the today's understanding of the laws and the Manusmriti or other Smritis may not stand to the constitutional guarantees that we have. But nothing wrong being a student of law or a researcher to find out what was it and accept and assimilate the best practices that were prevailing in this great country in the form of the Smritis, where Raja Dharma has been propounded in a wonderful manner. And even today, most of our court proceedings are practically akin to what has been practiced several centuries earlier in this country. I think the time that was allotted, that was of course made available to Krishnan, was not sufficient to deal with such a vast subject. Anyway, I am personally privileged, and I was benefited by the lecture, and it took me to my ML days, where I had discussion with my Professor B.N. Sampath, who has written a book on Vijnaneshwara as well in Kannada, titled as Paramahamsa Vijnaneshwara. And I had also had an occasion to make little contribution in reading the proof thereof for the said book. And I had my professor B.N. Sampath had visited Martur and handed over the books there to the Martur library. And I was working as additional district judge at Kalburgi, and I had taken him to Martur. There, all these are wonderful memories which has been recollected by me through this program. I'm thankful to all, and thankful to the persons who are conducting the present webinar for also permitting me to share my views in respect of the program. If possible, I would also join tomorrow and after for the programs. With these words, I thank once again all concerned for patient hearing. Namaste.
On behalf of the trust and all its members, we are grateful for Justice Srishananda to have aired his views. All his personal memories have now become the memories collectively of all the trustees of the Vijnaneshwara Pratisthana Trust also. May I now request the Honorable Presider, Shri Suresh V. Nadagowda, to address the audience with his presidential note for a few minutes.
Okay. Thank you, Sri Amit Kumar Deshpande. Elrigu namaskara. The most respected Sri Basavaraj Patil Sedam, former member of the Parliament Rajya Sabha, who has inaugurated this webinar. The most respected speaker, who made a very excellent presentation, Sri V. Krishnan, scholar Dharma Shastra. Most respected Honorable Justice Srishananda, Honorable Justice Srinivas Harish Kumar, Sri M.B. Nargund, Additional Solicitor General of India, who are present. Sri Kadi, my esteemed colleagues in our University Law College, Professor V. Sudesh, Dr. Satish Gowda, Dr. and respected principals, law colleges all over Karnataka and even outside. Indeed, we are very happy to organize this program. And in fact, Sri Madevaya called me long back, almost about 6 months back. And of course, he contacted me through our former registrar, Professor Potresh, who is a renowned historian and a professor of history at Tumkur. And in fact, we had plans to have some program related to the life and contribution of Vijnaneshwara, but due to unavoidable circumstances, it did not materialize. And suddenly, about 15 days back, I had a call from Sri Amit Kumar Deshpande. And in fact, it was a big surprise for me. And he proposed to organize this program to commemorate the 900 years of authorship of this great work, Mitakshara, authored by great sage Vijnaneshwara. And I readily accepted to be associated with the Vijnaneshwara Pratisthana Trust. And in fact, later they wanted to add even the CUK, Central University of Kalburgi also. And as such, this program has been organized to pay our respects and honor to the great jurist of the 12th century, whose work is like a magnum opus, which is also described as cornerstone of Indian jurisprudence. And in fact, the guest speaker spoke very elaborately on various aspects of the role of king, Rajadharma, that is to protect the good people, protect the welfare and well-being of the society, and also to punish the bad elements of the society, so that there can be a peace and justice and harmony in the society. And indeed, the Vidyaneshwara is to be remembered and celebrated by all of us, particularly the Hindus, because of his great work, which is being followed almost all over India, except in the state of West Bengal and Bihar, West Bengal and Orissa. So it is not only the principles of governance and the principles of administration of justice. We also should remember and be grateful for giving us the law related to how to live our life, then what should be the rules for marriage, and also partition, inheritance, succession, and whatnot. So what should be the role of the Karta? And of course, Honorable Justice Rishananda has highlighted in his remarks that Vidyaneshwara we do remember only for the Hindu, his contribution to our personal laws and all that. In fact, his contribution to Raj Dharma, the role of king, and all those things are not considered and not even taught that seriously in the law colleges. And in fact, the Rama Jois, who is, we are really proud that he is one of our illustrious alumnus who has made a significant contribution for the development of the Martur, the center of the work and life of Vidyaneshwara. And in fact, we should remember the great person, because except for few changes and alterations from time to time to suit to the changing needs of the society, particularly during the British period, and subsequently after India attaining the independence, we have gone for codification of the laws, and we have in fact failed to bring one comprehensive Hindu law code, but we have brought in the rules relating to the regulations of the activities and conduct of the Hindus in the form of 4 different legislations. It is known to each one of us, that is Hindu Marriage Act, Hindu Succession Act, Hindu Adoption and Maintenance Act, Minority and Guardianship Act, and all those things. And in fact, we need to make known to the younger generations about the great work and the contributions of Vidyaneshwara. And in fact, I propose, in fact, it should be made as mandatory for all the law students to make a visit, pay a visit to the center, Martur Center, to get to know about and to get the feel of the land where the great sage worked, stayed, and made his great contribution, which is a beacon light for all of us, even in the present days. So with these few remarks, I once again thank Mr. Amit Kumar Deshpande and also Sri Mahadevaya for providing this opportunity to University Law College to be associated with this particular program, and also providing me an opportunity to chair this session of the lecture by Sri Krishnan, who has made a very significant, thought-provoking presentation. So with these few words, I thank once again, and I conclude my presidential remarks. Thank you.
Thank you, Sri Suresh Vinaragoda, sir. Thanks a lot.
Thank you, sir.
Before I request Sri Mahadevaya ji to give his vote of thanks to everyone here. I would again remind all the audience here, the spectators here, and also would request all of them to rejoin tomorrow at 5:30, in fact at 5:25, so that the guest speaker would continue his lecture or the talk on this topic. You all have seen how erudite and how simple is his explanation with all the details that are required. May I request Sri Madhavaya Karadalli avarige manvi ಮಾಡ್ತೇನೆ.
Amit Deshpande sir. So
Yes,
for
sir.
the information of you and Madhavaya sir, we have also organized one more special lecture on contribution of Vidyaneshwara to Indian jurisprudence by that is to be delivered by Sri C. Sharma ji, who is the director of NAC, and in fact who is also an expert in Dharma Shastra and all that. That will be on 10th. That is in a physical mode.
Very
At
nice,
our
sir.
university Mark Stage.
Very nice, sir. We all would be looking forward for that event again. All the best to you, and please kindly circulate the link so that we all can participate.
Now we are going to print his presentation. It will be around 200 pages. That we will send the copy to you and your center.
Mr. Madhavaya Karadalli ji, ದಯಮಾಡಿ.
ಧನ್ಯವಾದಗಳು ಸರ್. ಇವತ್ತಿನ ತರಂಗ ಮಾಧ್ಯಮದ ಮೂಲಕ ವಿಜ್ಞಾನೇಶ್ವರರ ವಿಚಾರಗಳನ್ನ ಜನಗಳಿಗೆ ತಲುಪಿಸಲಿಕ್ಕೆ ಆಯೋಜಿಸಿದಂತ ವಿಷಯದಲ್ಲಿ ಶ್ರೀ ವಿ ಕೃಷ್ಣನ್ ಅವರು ತಮ್ಮ ಪಾಂಡಿತ್ಯಪೂರ್ಣ ಭಾಷಣವನ್ನು ನೀಡಿದ್ದಾರೆ. ಅವರಿಗೆ ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನದ ಪರವಾಗಿ ಮತ್ತು ಎಲ್ಲ ಪಾರ್ಟಿಸಿಪೆಂಟ್ ಪರವಾಗಿ ನಾನು ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತೇನೆ. ಈ ನಮ್ಮ ವೆಬಿನಾರ್ಗೆ ಯೂನಿವರ್ಸಿಟಿ ಲಾ ಕಾಲೇಜ್ ಬೆಂಗಳೂರು ಮತ್ತು ಸೆಂಟ್ರಲ್ ಯೂನಿವರ್ಸಿಟಿ ಕರ್ನಾಟಕದ ಕಾನೂನು ವಿಭಾಗದವರು ನಮಗೆ ಸಹಕಾರ ನೀಡಿದ್ದಾರೆ. ಇದರಿಂದ ಒಂದು ಉತ್ತಮವಾದಂಥ ಸಹಕಾರ ಆಯಿತು. ಇದಕ್ಕೆ ಕಾರಣೀಭೂತರಾದಂಥ ಶ್ರೀ ನಾಡಗೌಡ ಸರ್ ಅವರು ಅಷ್ಟೇ ಅಲ್ಲ, ಅವರು ಈ ಕಾರ್ಯಕ್ರಮದ ಅಧ್ಯಕ್ಷತೆಯನ್ನು ವಹಿಸಿ ಬಹು ಮಹತ್ವದ ಪ್ರೆಸಿಡೆನ್ಷಿಯಲ್ ರಿಮಾರ್ಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವರಿಗೂ ನಾವು ತುಂಬಾ ಹೃದಯದಿಂದ ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತೇನೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಥ್ಯಾಂಕ್ ಯು.
ಸದಾ ಸ್ಫೂರ್ತಿ ಇಟ್ಟುಕೊಂಡು ಸನ್ಮಾನ್ಯ ನ್ಯಾಯಾಧೀಶರಿಗೂ, ಪ್ರಾಚಾರ್ಯರಿಗೂ, ವಿದ್ಯಾರ್ಥಿಗಳಿಗೂ, ನ್ಯಾಯವಾದಿಗಳಿಗೂ ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಭಾಗವಹಿಸಿ ಈ ಕಾರ್ಯಕ್ರಮದ ಯಶಸ್ಸಿಗೆ ಪ್ರತ್ಯಕ್ಷ ಪರೋಕ್ಷವಾಗಿ ಸಹಕರಿಸಿದಂತ ಎಲ್ಲ ಹೃದಯಗಳಿಗೂ ಕೂಡ ನಾನು ಧನ್ಯವಾದಗಳನ್ನು ಅರ್ಪಿಸ್ತೇನೆ. ಸರ್, ನಾಳೆ ಕೂಡ ಈ ಕಾರ್ಯಕ್ರಮ, ಟುಮಾರೋ ಆಲ್ಸೋ ದಿಸ್ ವೆಬಿನಾರ್ ವಿಲ್ ಕನ್ ಟುಮಾರೋ ಅಂಡ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. Same time, sir. Okay. Tomorrow that program is going to be presided by Honorable Vice Chancellor of Central University. I request all the participants to send this message to all the extra participants. Let them share this thought of Mr. Krishnan and all. Thank you one and all.
Thank you, sir. Thank you. ನಾಳೆ ನಾಡಿದ್ದು ಬೇಕಿದ್ರೆ ನಮ್ದು ಜೂಮ್ ಪ್ಲಾಟ್ಫಾರ್ಮ್ ಯೂಸ್ ಮಾಡ್ಬೋದು, ನೀವು ಹೇಳ್ತೇನೆ ನಾನು.
ಆಯ್ತು ಸರ್.